What is the difference between a will and a living trust? And why is it that if you're over 18, if you have any assets, you should have a living trust and not just a will? Hey friends, I'm Mark Gilfix. I've worked with hundreds of families on estate plans, and we get this question all the time. I already have a will. Why do I need a living trust? Or what is a living trust? By the way, living trusts are known by many different terms. They're known as revocable trusts, revocable living trusts, trusts. Let's think of this as the standard living trust or revocable living trust. They're the types of trusts you can change at any point. So what is the difference between a living trust and a will, and why is it that you really need a revocable living trust? So if you have a will, everybody's pretty familiar with that, right? You say, I bequeath all of my assets to this person or to these people. And it generally can be effective. But the problem is if you have more than a very small estate, like if you have more than tens of thousands of dollars, or if you have real estate and you just have a will, okay, maybe the will determine where things go, but there's two big problems. One is your assets are going to be stuck in the courts for up to 2 or even 3 years in something called probate if you just have a will. A will has to be overseen by a court after you pass away. It has to go through a probate. The fees are really high and they're set by the court. They can be tens of thousands of dollars. It's totally public. So anybody, if you see a celebrity who passes away and you see everything about their estate. I remember when James Gandolfini passed away, the star of The Sopranos, there were all these news stories about his estate. Why was that our business, right? It's because he just had a will. So everything was public before it went to his kids. So it's public, very expensive. The fees are really high and it takes forever. We've seen some probates last up to 3 or 4 years. So you might have that reading of the will, which doesn't really happen in real life. And it could be years before your loved ones get anything. It's terrible. Who deals with paying the bills in the meantime? So it's horrible that way. But the second big problem aside from probate is that a will doesn't help you while you're living. You name an executor in a will, and they only have a role to play after you pass away. They're the person who represents your assets and your estate in the court through the probate. But they can't help you if you're sick while you're living, or if you need help with bill paying or other assistance if you're incapacitated or out of it when you're alive. The will doesn't help you at all. A living trust can solve both of these issues largely. So if you have a living trust and it's properly funded, when I say properly funded, that just means assets should be titled in your trust. So in my case, it shouldn't be in the name of Mark Gilfix. It should be Mark Gilfix as trustee of the Mark Gilfix Living Trust. Doesn't change your taxes. It's actually fairly straightforward. You can always get expert help on doing that right. But as long as your assets are in your trust, when you pass away, they don't go through probate. They are administered. There's something called a trust administration, and it does require lawyers to be involved, but the process takes a fraction of the time of a probate. It's not public, and the fees are typically a fraction of the fees of probate. Probate fees could be 2 or 3% of your estate. Trust administration fees are maybe 1%, and sometimes even less, sometimes a little more. But the bottom line is a trust lets you privatize your estate. After you're gone, it stays in the family, it's not exposed to the courts. And 2, a trust, you name successor trustees. They play the role of executor, as many people think of it in wills. So the trustee, whoever you name as your backup trustee, by the way, you are your own trustee when you create the trust. You're in charge of your trust. But that trustee steps in and basically does what an executor would do, but it's administering the trust. They oversee the distribution of your assets, make sure the right tax filings are done. But your successor trustee can also help you while you're living. So if you're incapacitated, your successor trustee can show a doctor's note or proof that you're incapacitated, and they can pretty seamlessly step in to manage your major assets if you're still living, but if you're incapacitated or sick. So a living trust is just much better than a will. It can end up saving your family tens of thousands of dollars. There's also a lot that you can do with a trust that you can't do with a will, like build in different restrictions for your kids or build in different protective structures for other family members. It privatizes your estate, helps you avoid probate, and lets you name successor trustees who can help you while you're still living. So it's crucial to set up a living trust and do it with a lawyer, do it with an expert. If you have kids, you have to make sure you do it right. If you have any significant assets, do it right. There are major tax implications for setting up the right versus the wrong structure of a living trust. If you're married, that's a subject for a different day, but I hope this helps explain it. A trust essentially privatizes your estate. If you just have a will or don't have a will, your assets are going to be stuck in the courts for potentially years after you pass away. Now, how do you stay on top of all of this? Subscribe, comment, follow us at the Gilfix Law channel. Leave us a comment if you have any questions. And make sure you have an estate plan in place. And if you haven't looked at your estate plan in a long time, even if you have a living trust, you should update it. You can update your living trust anytime you want, as long as you have capacity. So make sure you have that living trust and not just a will. Stay tuned for more.